No, no.
Okay.
Okay. So I have started recording. You can start. I'll go on
Yeah.
mute.
Good evening, everyone. So today's lecture is on Indian Partnership Act 1932. So, uh, generally, most of the Indian acts are based on colonial laws of England or UK. You can say that. So India got independence in 1947, but the Indian Partnership Act is of 1932. So that means that the Indian Partnership Act is much before Indian independence. So Indian Partnership Act is basically a follow-up, or you can say that uh, it got inspiration from the English Partnership Act. Okay. So what does partnership means? As far as Indian Partnership Act is concerned, it is a partnership which in a commercial sense. So what does it mean by commercial sense? Uh, In a commercial perspective, that means there must be business, there must be people who are commercially related to each other, there must be profit, and there must be loss. Okay. So Indian Partnership Act, uh, as far as the law of partnership is concerned, in India, as of now, there are two partnership laws. One is the Indian Partnership Act of 1932, and there is limited liability partnership, which is much younger and much newer to the Indian Partnership Act. So, Section 4 of the Indian Partnership Act defines partnership. What is partnership? As per the Act, partnership is an agreement. Partnership is an agreement to share profits of the business. Please note that it says it's an agreement to share profits of the business. So does that mean that Indian Partnership Act states or stipulates only profits or only sharing of profits between the partners? If that be so, then what about the losses? So it was interpreted by the Indian courts, Indian Supreme Court, and other high courts that the definition of partnership, sharing of profits of the business is explicitly stated, but which includes or it is implied that when we are sharing profits, we have to share the losses also. But the Indian Partnership Act doesn't mention anything about the losses, but it is implied. So the definition has two things. One is expressly states that is sharing of profits, and there is impliedly states that the partners have to share losses. Then, what are the key elements of a partnership or partnership? There must be an agreement, and that agreement has to be a written one. Number one, there must be business. There must be sharing of profits, which includes losses, and there must be a mutual agency. Why a mutual agency? Because a partnership is a part of a contract. Previously, Indian Contract Act was 1872. That partnership was part of the Indian Contract Act. But later, in 1932, we had a separate act of Indian partnership. Partnership arises from contract, not from status. Why it is stated that partnership arises from contract, not from status? Because for a partnership, we need a valid partnership agreement. And why not from status? It's like a Hindu undivided family. A Hindu undivided family has its own joint business. They are the so-called partners or members of a Hindu undivided family. By their status, are part of that business. But in partnership, It is not two status. That means suppose A and B are partners. That includes only A and B, not the legal heirs or the heirs of A and B. By status, they are not partners. To become a partner, you have to be a part of that partnership to an agreement. Uh, am I clear? Hello? Hello?
Yes, you're clear.
Okay. Then there comes what are the different types of partnership? Partnership can be a general partnership and partnership can be a particular partnership. What are general partnership? General partnership means it's an unlimited liability. That means if there are two partners, then the liability is unlimited. There is full liability. Okay. When it is particular partnership or specific particular partnership is when the partnership is for a specific project or a venture. Let's give an example. Suppose A and B had created a partnership that they will do business of selling iron ores. That is a general partnership. But how it will be a specific partnership? If A and B joins a partnership, specifying that they will be partners or selling iron ore for a particular project. Let's for say A and B made a partnership that they will sell iron ore or iron sheets to for Tata Nano. Then it is for a specific venture or specific project. Then it is a partnership for a specific venture or project, and it's like a particular partnership. And for a general partnership, they can sell it to anyone. It's a general partnership. Then what will be the duration of partnership? So by creating a partnership, does that mean it will carry on for time immortal? No. In a partnership agreement, we have to specify the time limit till when this partnership will exist. It might be for 1 year, it might be for 10 years, and there's another clause. It might in one of the clauses we might mention that the partnership at will. That means the partnership has no fixed duration. The partnership will exist as long as the partners wish it to be. The moment the partners want it to end, they can end the partnership. So, in a partnership agreement, there will be no time limit or there is no validity of that partnership. So, both are correct. We can mention the time limit. Okay, Yuri, tell me what.
So in general, or the another you said, so both partnership we need to check the timeline when project is going to complete, right?
No, project, if it is a particular partnership,
Uh-huh.
then there's a time limit for the project.
Okay.
As I given an example of Tata Nano. Suppose the
Uh-huh.
Tata Nano project is for 2 years,
Uh,
then the partnership uh, will exist for 2 years because
2 years.
we have to
Because we are doing
supply
for
our
specific client, right?
specific client or specific project.
Exactly.
Okay.
If
In a
partnership
general,
usually
yeah.
between two friends, for example, for specific
Yeah.
production, may it will take
Okay.
10 years to establish the business. So in
Okay.
that case also we have to set up the deadline, or like it will go like till the
No,
they want to continue.
that there is no deadline. Deadline are for agreements or projects. For a
Mhm.
partnership, for a partnership, you cannot leave it a blank, and the partnership will exist till time immortal or till
Mhm.
endless time. We have to
Mhm.
mention a specific time that the
So
partnership
in both
exists.
the both the partnership there will be a time limit. No? That is my question.
Yeah, yeah, there will be time limit, but
Okay, okay, understood.
but but there's a difference. In one, we are mentioning it for 2 years, 3 years, or 1 month, 2 months. We are
Okay.
uh, mentioning the number of days and number of years. In another, where we are saying that partnership is at will, there is no time duration. or
Okay.
there is no year duration. There
Uh-huh.
we are stating that the partnership will exist till the partners want it to exist. It
Understood.
might be for 1 year, it might be for 10 years. The moment the partners want to end the partnership, they can end it.
Okay. So there might be a circumstances where
Yeah.
one, like both the partners do not want to exit and the venture is still continuing for more than 10 years. So in
Yeah,
that case also the business will be working, right? It's ongoing process.
yeah, yes. So basically, you cannot leave it blank that we have a partnership. We have to
Yes.
mention it either in years that the partner or the
Completion of the
partnership will
document, we
exist.
have to say put some clause into the document, right?
Yeah, yes. A
Understand.
partnership at will. Generally, people write for general partnership. We write partnership at will.
And
For a project, for a limited project, we mention the years or the
understood.
time limit.
Yeah, yeah. Thank
Okay,
you. Thank you.
okay, well, acha. So then, section 12 of this act classifies the rights of the partners. If there is an agreement, then there are partners. Then the partners have certain rights and liabilities, right? So, what are the rights of a partner? The, the first right of a partner is to participate in the business. If I am a partner to a business, then I have a right to participate in the business. Okay. But there is another concept of a sleeping partner. There are active partners, there are sleeping partners. Acha. Who are sleeping partners? Suppose there is a partnership firm where A, B, and C are partners. C, all key invest the capital. C invests a capital of 1 lakh, suppose. And he says that I am investing the capital. I will not participate in the daily work of the partnership firm. I will only bear the profit and losses. I will not participate in the day-to-day business. Clear?
So again, one question. For
Yeah,
example, as you said, sleeping partner. So they
yeah,
were not exactly the participating in the venture, but they have invested their money in the venture, right?
yeah.
This is exactly happen in sleeping partner, right? But at
Yes,
the time, at the end, and when they want to share the profit, he will be the part of the profit, right?
yeah, yes.
But
So
he will
by
not put
party,
his effort while the work is going on.
no, he is not part of the day-to-day business or day-to-day
Day to day,
management.
matlab the work is
Ha,
ongoing and whatever the office work is there, he will not participate
yes,
in that.
he will not
Only thing
participate.
is he
He
will
has
continue
only invested the capital.
investing in the venture and he will take his
Yeah,
share, right? That is
yes,
sleeping
they
part.
take his share. Okay.
Okay.
Now that when we say participate in the business also includes investing of capital. Even if I'm not regularly in the day-to-day business, but when I'm sharing the burden of the capital, then that means I am also participating in the business by sharing the capital. Clear? Hello? Hello?
Yes, yes, clear, clear.
Okay,
Clear,
okay.
clear.
Okay. Then right to equal share of profits. When we say right to equal share of profits, it depends on on the amount of capital we have invested. Suppose there are A, B, C, D, four partners, and the total capital is 1 lakh. So if so, that means or that's supposed to mean that each of the partners has invested 25,000 rupees, which the sum assured is 1 lakh. But what if someone has invested 50,000 and the 25,000 and the 10,000 and the 15,000? So there is no equal amount of investment in the business. So when there is sharing of equal share of profit will only happen when there is equal investment. If there is not equal investment, then sharing of profit will depend on the amount of shares that each partners has invested. Clear? Still, Rohit.
Clear, clear.
So exactly the like very basic thing I'm asking. For
Yeah,
example, I have invested 50, Mr. Sunil have invested 50, and you are the
mm,
main owner. You are invested 2 lakh rupees. So once
Okay.
it's come to profit sharing, that distribution not be equal. So
No.
you are trying to say it will be pro rata basis, or the amount we have invested on that we will get the return of the money.
Yes. The amount we have invested,
Mm-hmm.
based on that, the profit will be shared.
Because in
But
the business there
yeah,
will be loss also, right? So if
now there will be loss also. The loss will be shared as per the percentage of investment we have done.
exactly, so example, I'm just asking that, like, if there will be a loss of 1 lakh rupees, you have
Yeah.
invested two, Sunil
Okay.
and me have invested 50,000. So the
Yeah.
loss of like what are the losses occur in the organization. So the
If there
loss
is a loss of
will
2
be
lakhs rupees,
equally.
then my
Huh.
loss will be 1 lakh. Your loss will be 50,000. Sunil's loss will be 50,000.
So it is not equal share, right?
No, no,
The
it's
loss
not
will
equal
be
share.
different and the profit will be different.
No, the sharing of profit and loss
Mm-hmm.
is will be same as far as the investment is concerned. If
Acha.
forget
Okay.
about the amount, suppose I have invested 50%, you
Mm-hmm.
have invested 25%, Sunil has invested 25%. So
Okay.
if there is a profit, then I will get 50% of the profit. You will get 25 of the percent of the profit. Sunil will get 25 of the
Portion
profit.
of amount we have invested, that
Invested.
percentage of return will get, right?
Yeah, okay, return will get.
Oh,
Similar with loss. If there is a loss, then the similar amount will happen. Now,
okay.
suppose there is an unequal amount of investment, but in the partnership agreement, we have agreed that the profit will be shared equally, irrespective of the matter, what the percentage of investment we did. In that case, the profit will be equally shared. Since this is an agreement, a partnership is basically an agreement. If in the agreement from the very beginning we have agreed that whatever be the amount of investment or the percentage of investment, the sharing of profit will be equal. In that case, even if I have invested 50,000, Sunil 25,000, you have 25,000, the sharing of profit will be equally distributed. Clear?
Okay, okay, yeah.
That's right. Another important right of the partner is right to access book of accounts. Right to access books of accounts. That means each and every partner has a right to get access to the book of accounts, to check the accounts, to check the profit and loss or the daily transaction of the business. Even a sleeping partner has equal right to access the book of accounts. Clear?
Clear.
Okay. These are rights. When there is a right, there has to be some duties. So what are the duties of a yes, Sunil?
हेलो पीयूष
Yes, Sunil.
वन थिंग में जो टॉपिक पे जो डिस्कस हो रहा है ना वो
हाँ
भाई सिंगल वन टॉपिक एक बार बताते जाएंगे ना तो नोट डाउन भी कर लेंगे ठीक है कंटिन्यूअस हो रहा है ना
ऐसे
तो उसमें कंफ्यूजन हो जा रहा है
मतलब सिंगल क्या सिंगल
हाँ जैसे पार्टनरशिप की
टॉपिक
जो डिटेलिंग किया है ना आपने भाई
हाँ
सिंगल वाइज जैसे स्लीपिंग पार्टनर्स जो गए जनरल पार्टनरशिप हो गई पर्टिकुलर पार्टनरशिप हो गई जो टॉपिक के बारे में बता रहे हैं उस टॉपिक के बारे में थोड़ा सा नोट डाउन भी करने का है मुझे बाद में
सुनील
रिवीजन करने होगा
हाँ वही बोल रहा हूँ सुनील जो ये जो
हम्म,
ग्रुप है ना ग्रुप में देखो
हाँ
ऑलरेडी इसका पूरा दिया हुआ था
हाँ हाँ
लाल
पीडीएफ
हाँ
है मैंने
वो
देख
दिया हुआ है तो
मैं
ये-
वो एक्चुअली क्या है उसमें
हम्म,
प्रेजेंटेशन बना के दिया हुआ है ना उसकी डिटेलिंग
अच्छा
नहीं है उसमें
ठीक
डिटेलिंग
है
नहीं है उसमें प्रेजेंटेशन है ना तो जैसे आप डिटेलिंग बता रहे हो ना तो वो नोट डाउन कर
हम्म,
लूंगा मैं तो मेरे को थोड़ा
ठीक है
अलग थोड़ा सा
ठीक
और
है
हो जाएगा
सुनील
ठीक है
ये होने के बाद मैं ग्रुप में शेयर कर देता हूँ
चलेगा
ठीक है
थैंक्स
अच्छा now what are the duties of a partner the duties of the partner first and foremost when there is a partnership in the partner there must be a clarity between the partners there must be honesty between the partners and there must be good faith and full disclosure Acha. Why good faith without good faith you cannot have a healthy business that's very business A basic, very
Yes.
basic. That for a good business or any good relationship, you must have good faith. And why full disclosure? Because it is a business, right? If there is not full disclosure of the daily business or daily happenings, then the other partners, generally in a partnership, one partner is active, who mostly looks after everything,
Okay.
right? So if there is not full disclosure, then the other partners will not know what is happening, right? So why full
Yes.
disclosure? Suppose uh, I have given an example of a business of iron ore. When I am selling iron ore, that means I am buying it from somewhere. So
Yes.
there must be a full disclosure that what was the buying cost of the iron ore, and at what amount I am selling it to the party, and the amount of profit I have generated. What are my expenses? Just by buying doesn't mean that will be, and selling. The difference is not my profit. After buying, there are other uh, daily costs. There are recurring costs. There are uh, infrastructural costs. So all will add to the cost of the product. Thereafter, I am selling the product. So each and every minor details has to be disclosed to the other partners. It, there has to be there has to be entire clarity, not some clarity. There has to be entire clarity. Even if in a partnership firm, uh, I buy a pencil in the name of a partner, in the name of the partnership, I have to disclose that I have bought a pencil from the accounts of the partnership. Clear?
Clear.
Acha. Then
Clear.
duty to carry on business for common advantage. Here, common advantage is very important. When it's a partnership and there are partners, a partner cannot do business for his personal gain. A partner has to do business for the common gain or the common advantage. I cannot do a business where only the outcome of that business is advantage to me only. It has to be common advantage of all the partners. Clear?
Clear.
Acha. Then there is a duty not to compete with the firm. Suppose uh, you are part of an IT firm, okay, and you are an IT technician. So you are doing business or you are working for the partnership firm. You cannot uh, simultaneously have another business that is competing with your firm. So how to compete with the firm? Suppose there is an auction or there is a tender. The company files a uh, requisite or do the or fulfills the papers for an auction. You being a partner of that firm, you cannot simultaneously file another paper for an auction or a tender in your name or in the name of your spouse or friends. That means you cannot have an office of profit that conflicts with the interest of the firm. Clear? Thoroughly. Bolo.
Like you're saying, if I am have a partnership with you, so
Yeah.
I cannot go for any another venture or any other type
No,
of
no,
option or buying a property sort of business part,
no.
right?
You can no. Let me be clear. You can have uh, be part of innumerable business if there is a clause that you cannot do that. What I am trying to say, you cannot do any act that com- contradicts with the interest of the firm you are partnered with or that competes with the firm.
Okay, so which is
Yes.
related to my current company or current partnership, that should not
Yeah.
impact, right?
Yes. You are a lawyer, right? You are
Right.
part of a law firm. You are
Okay.
part of a law firm. And the law firm has a certain client, and the law firm is representing his client in a court of law. You are
Okay.
partner of that firm.
Mm.
But you are representing the OP, the opposite party. That means you are competing with the firm, although you are partner of that firm. That is not
Okay.
allowed.
Understand. Understand.
You can have your own uh, law practice. You
Right.
can
Right.
have any other independent case. client, but you
Okay.
cannot compete with a law firm in a
Yes.
case
Competitor
where there
partner.
is a conflict, of interest.
Okay.
Okay.
Understand. Thank you.
Okay.
Thank you.
But then comes, it is a duty of the partner to indemnify the firm for losses caused by fraud. It is a duty of I repeat, it is a duty of the partners to indemnify the firm for losses caused by fraud. That means, you being a partner, if you if the firm losses because of your act, or because of your fraudulent act, then you have to indemnify the law firm, or you have to indemnify the partnership firm. Clear? The
clear.
firm might suffer losses due to your mistake. A mistake might happen by anyone, even by a senior partner, or an intern. A mistake can happen. But if that loss is a result of a fraud done by you, then you have to indemnify that firm or the business. Clear?
Clear.
Clear.
Okay. Then comes the liability of a partner. You have uh, the law of torts. In a law of tort, there's a concept of joint liability and several liability. What are joint liability? Joint liability means will be the liability is shared by jointly by a number of people or more than one people. And several liability means the liability will be shared by an individual only. It's your personal liability, not a joint liability. I- In case of a partnership firm, Section 25 states that there is both joint liability and there are several liability. Why? Suppose due to the act of the firm, a client or a customer has uh, lost some certain amount, then it is a joint liability of the partners to give him compensation or to make his losses. Clear?
Clear.
Okay. When there is a several liability, it is when it is due to the fault or fraudulent act of a particular partner, a single partner.
Hello.
Uh, Hello, am I
Yeah.
disconnected?
Yeah,
Okay.
you went silent suddenly, and your note taker is gone.
Okay, let me rejoin it.
Hmm.
I think I have joined now. Right?
Yes, you
It
have.
Yes.
says Pijush circle late, but you can hear me now.
Yeah. Yeah.
Okay, I don't know
Yes,
why.
I can hear you.
Okay, okay. There is unlimited liability. When there is unlimited liability, personal assets at risk. अच्छा. Suppose there is a difference between partnership firm and a company. A company is an individual. It has a separate identity. A partnership firm doesn't have a separate identity. The identity of a partnership firm is the identity of the partners. A partnership firm, most importantly, can be a registered partnership firm or an unregistered partnership firm. So, what makes the difference? If it's a registered partnership firm, then the partnership firm can file a case or can sue a person in the name of a partnership firm. But if it is an unregistered firm, then the partnership firm has to sue a person through or by the name of the partners. In the name of the partners, the case will be filed, not in the name of the partnership firm. Clear?
Clear. Clear.
Okay. Then comes is there any limit of the number of partners a partnership firm can have? As per the Partnership Act is concerned, there is no limit. Even a partnership firm can have 100 partners. The partnership firm doesn't specify that it states that the minimum number required is two partners. the maximum number is not mentioned. It can be 100. But there's a catch. But the Indian Companies Act says that if a partnership firm has a uh,
Your voice is gone.
hello,
Your voice
can you
just
hear?
broke.
Okay.
Now you got to repeat what you were telling.
Yeah. See, as per the Partnership Act is concerned, it says that to make a partnership firm or to make a partnership, there must be at least two partners. There must be two persons. But it doesn't mention the maximum number of partners a partnership firm can have. A partnership firm technically can have 100 partners. There is no restriction in that. But the Indian Companies Act of 1957 is stated that a partner a partnership firm can have a maximum of 20 partners. If there is more than 20 partners, then it has to be registered as a company. Clear? Hello?
If
हाँ
we
clear.
they have more than 20 partners, then what you said?
If there is a more than 20 partners, then that business has to be registered as a company under the Indian Companies Act.
We have to list the company, right?
You have to that business has to be listed as a company and registered under Indian Companies Act.
Okay, okay.
So
Okay,
limited.
it's limited. But then,
Yes.
but the partnership act doesn't specify that after 20 years it's not allowed. It says minimum two, maximum it can be 100. But the Indian Companies Act says that if it is 20 and above 20, it has to be a company. Clear?
Yeah, clear.
Okay. Acha. Suppose a partnership firm started with two partners. So does that mean new partners cannot be added or new partners cannot be inducted? No. New partners can be inducted anytime, but it has to be mutual. If there are two partners, a new partner is being inducted, then it has to be mutually decided or mutual consent is needed. Then then a new partner will, will join that partnership. So we call that partner as the incoming partner. There's a consider incoming partner and outgoing partner. Who is an incoming partner? Incoming partner are partners who are joining afresh, and outgoing leaving the partnership. So, what about the liability of an incoming partner and outgoing partner? Sunil, do you want to say anything?
No, nothing.
Okay. So, the liability of incoming partner is the liability only for future legs. That means an incoming partner, the day he or she joins a partnership firm, his liability starts from that day only, not the past act. And in case of outgoing partners, his liability is only for the past act till the date he resigned. Am I clear? I'm repeating again.
Yeah,
So the
clear.
liability of an incoming partner is from the date he joins the partnership firm, not for the future acts, and not for the not for the past acts. His liability, the incoming partner's liability, is only for future acts.
Okay.
In case of outgoing partners, his liability is not for the future acts. His liability is only for the past acts. Achha. In the ordinary, yes, Rohit.
For example, the venture is 10 years old.
Yeah.
Okay. And I have joined their partnership firm as a
Hmm.
new member, like after completion of their business 6. So I
Six
am
years, yeah.
resigning after 4 years. So my
Hmm.
exit liability will be for only for 4 years, right?
Exit liability.
Like
I didn't
exit,
get you.
if they are bearing a losses, the I have to pay only 4 year losses, right?
No.
Then
Suppose there are two partners. The
okay,
partnership firm existed for 5 years, and
okay,
you are joining on the sixth year. So
okay,
your liability starts from the sixth year. If
okay,
there is if So the loss incurred during the previous 5 years
Uh-huh.
is not your liability.
Okay. Or and in
Your,
seventh year, if I resign, so my liability is only for 1 year,
your
right?
liability is only for 1 year from the date of joining to the date of resignation.
Understand. Understand. Thank
Okay.
you. Yeah.
Okay. Welcome. So, in general or in ordinary course of business, under section 19, the acts of the partners bind the firm, only firm, and the acts of the partner doesn't bind another partner. The act of a partner will only bind the partnership firm. Clear?
Clear. Clear.
Okay. So, what is the difference between a partnership firm and other form of business? Difference between partnership and company. In case of partnership firm, there is no separate entity of the partnership firm. But in case of a company, the company has a separate entity. Acha. Clear? Liability. In case of partnership firm, there is unlimited liability. In case of other business, there is a limited liability. Acha. Is registration mandatory in case of partnership firm? No. In case of partnership firm, the registration of a partnership is optional. But in case of other business, it is mandatory. What are the other business? Apart from partnership firm, it can be a company, it can be an LLP. In both the cases, in case of LLP and a company, the registration of the business is mandatory. But in case of partnership firm, it is optional. What is the difference between a partnership firm and an LLP? In case of LLP, it has a limited liability. Plus, it is a body corporate. Is it clear?
Yes. Clear. Clear.
Okay. Now, what is the registration of firms? Registration is optional, not compulsory. In case of partnership firm, Section 69 says that disabilities of an unregistered firm. Section 69 specifies what are the uh, drawbacks of an unregistered firm. Clear? Acha. Uh, in case of a partnership firm and a proprietorship, in the case of proprietorship firm, the the PAN is in the name of the proprietor. A proprietorship firm doesn't need a separate PAN card. But in case of a partnership firm, you need a separate PAN card or an ID file.
What we
Because
need for a partnership?
for a partnership, you need a separate PAN card.
Separate PAN card. Okay.
PAN card. But if it is a proprietorship firm, we don't need a separate PAN card. The PAN card of the proprietor is used for the business of the proprietorship firm. But in
Okay.
case of partnership firm, see, there are people who do not who do a partnership business without having a PAN card, but that is illegal. It can be done only because it is an unregistered firm, but that is not the procedure. The procedure is for a partnership firm, whether it is registered firm or an unregistered firm, a separate PAN card is necessary. It's mandatory. Clear?
Okay, clear.
In case of a partnership firm, a partnership firm cannot sue partners or third parties to enforce contractual rights. If the partnership firm, uh, suppose there is a conflict between the partners, a legal conflict. So the partnership firm cannot sue the partners because you cannot sue yourself. A partner is part of the firm. A partnership firm cannot sue a partner, but a company can sue its director. Clear?
Yeah.
Clear.
The
Clear.
reason is the reason is a company has a separate entity. Partnership firm doesn't have a separate entity. Achha. Then how? Suppose the partners want to dissolve the partnership firm. How to dissolve a partnership firm? A partnership firm can be dissolved by an agreement or a mutual consent. How by an agreement? If in the agreement it was mentioned that the partnership firm will exist for 10 years. So after 10 years, it will automatically dissolve. No need to have a separate procedure. But
Got
if but if it is partnership at will, then there has to be a mutual consent. Then all the partners or both the partners have to mutually give consent that they want to dissolve the partnership firm. Suppose there are two partners and the partnership is at will, and one of the partners want to dissolve the partnership firm. Then the partner who wants to dissolve the partnership firm have to give notice to other partners that he want to dissolve the partnership firm. Clear?
Yes, clear, clear.
In both the above two cases, it was done by the partners. So there's another way, another two ways a partnership firm can be dissolved without the consent or without a mutual consent or through an agreement in the partner. How a partnership firm can be dissolved by the operation of law. That is by the date of the partners. Suppose there are two partners. One partner dies, then the partnership firm will dissolve. If other there is otherwise any other clause, if both the partners die, then the partnership firm will dissolve. If the partners got insolvent, if both the partners or all the partners have got insolvent, or the partnership firm has been declared as an insolvent, then the partnership firm will be dissolved. If the partnership firm is uh, involved in illegal activities, then by the operation of law, that partnership firm will be dissolved. Clear?
it.
Okay. Yes, sir. Then partnership firm can also be dissolved by a order of the court. When a court orders for such dissolution, if the partners are incapable, that means they are incapacity. Suppose the partners or one of the partners has suddenly become insane, or the partnership firm has uh, included a, a minor in the partnership firm. In that case, a minor cannot enter into an agreement as per the Indian Contract Act. So he is not qualified to be a partner. A minor can get benefit from the partnership firm, but he cannot be a partner to the firm because he is a minor. Then there is by the misconduct of the partners or the partnership firm, it can be dissolved by a court of law. By breach of agreement. Suppose the partnership firm breaches the clauses of the agreement, and a case has been filed in a court of law, and it has been proved that the partnership firm has breached the clauses of the agreement. Then the court might order, if it finds it fit and if it deems fit and proper, then the court will order for the dissolution of the firm. Clear?
Clear.
Yes, clear, clear.
Do you have any other question on that?
No, no, no.
Okay. Then the hello,
Yes, yes.
hello.
आवाज आ रही
Okay.
है?
Then
Your
comes
video is coming on. Video off karo.
hello.
Hello.
हाँ
Can you
हाँ
hear? Ah.
Yes.
See,
yeah, yeah.
another important part of a partnership firm or any business is the taxation part. Okay, for a partnership firm, the tax is there is a flat tax rate, that is 30% of the profit plus 4% cess. That means what the slab is the amount of profit the partnership firm makes. There is a flat 30% charges. plus 4% cess. There is a surcharge of 12% if the income is above 1 crore. Clear?
Can you repeat this?
I'm repeating. In case of a partnership firm, the taxation is there is a flat slab of 30%, and the profit the partnership firm makes on that amount, the tax will be 30% plus 4% cess. That
This
means
is for the taxation LLP also, na?
no, not for LLP. For LLP and partnership firm, it's same.
Okay.
But as far the flat taxation is concerned, it as you know that taxation changes with the budget, or
Yes, yes,
it varies.
flat taxes rate.
But but
30% plus 4%.
as of now, that for taxation of partnership firm and LLP, it is flat 30% plus 4%,
Yeah.
and the
Exactly.
surcharge is 12% if the income is above 1 crore. Clear?
Okay.
Surged. Okay.
Okay. So let me, as far as taxation is concerned, the rate might differ. Okay, with time.
Okay.
Acha. Then there is a remuneration and interest to partner. There is in a the partners not only get the profit.
Can you repeat? Hello?
You are
Your
not
voice
audible.
was gone. Your voice was gone,
Yeah,
Pijush.
yeah.
Ah,
In a
yeah.
partnership firm, the partners get a share of the profit, but apart from the profit, the partners might get a remuneration or a salary. Suppose in a partnership firm, there will be one managing partner or one partner who handle all the business.
Okay.
So that part, so in the agreement, the partnership agreement, it might be mentioned that the managing partner or the partner who handles the day-to-day business, he he will get a salary, a monthly salary. Yeah, it's not
Yeah.
mandatory. It's a decision of the partnership, decision of the partners or as per the partnership agreement. It
Okay.
might be there might be a clause that the managing partner will get a salary in excess to the profit at the end of the year. Clear?
Clear.
Clear, clear.
In that case, the remuneration the partners is getting is an expense for the partnership firm, right?
Yeah. Right.
But simultaneously, the remuneration or the salary the partner personally is getting is his personal income. That means the salary he is getting will be shown in his personal IT file that he has earned this amount as salary or remuneration, and
Okay.
the amount the partnership firm has given the partner will be in his expense account. That is the expense of the partnership firm. Clear?
Clear.
Okay.
So
I'm not going.
is
Yeah,
it is not, as you said, it is not compulsory, right? So
which is not compulsory. Oh,
if
it's the salary
one of
part.
the
Yes.
handling partner is requested at the time of agreement, in that case
Yeah.
they will write down one clause as he will get the remuneration, right?
Yeah.
Okay.
It is optional. See, what is a partnership agreement? It is basically a contract. Every clause is permissible if it is not contrary to public policy or if it is not illegal. So getting a salary is not an illegal one, or exempting a salary is also not an illegal one. So it is totally a mutual agreement between the partners, whether the managing partner will take his salary or not. If he takes, it is a legal one. If he waives it, it is also legal.
Okay.
Okay, okay, okay.
Suppose that in case of company, a director of, gets a salary, an independent director gets an remuneration as an honorarium for each and every sitting, right? But in case of a partnership firm, they not it's not like that. Partner can take his salary, he cannot take his salary. It depends on him or as per the agreement of the partnership.
Okay.
Clear?
Yeah.
Clear.
Yeah. Anything you want to know or ask?
No. Thanks. So far it's good.
Okay. If you have any doubt, then
Yeah,
message
we'll
me
ask.
in the
We'll ask.
group. And
Okay.
as far
Okay.
as Sunil is concerned, Sunil, I will forward it to you. Right? In the
Okay.
group.
Okay. Okay.
Okay. So shall I end the
Yeah, we can
Yeah.
end,
Yeah.
but
Sure. Sure. Sure.
it will
yeah, yeah.
mix up with
Thanks.
the entire
Thanks.
partnership.
Okay. Thanks everyone.
Thank you,
ठीक है,
thank you.
thank
We'll
you
One
we'll
thing.
so
One thing. Pijush, hello.
Yeah, yeah, yeah.
एक
सुनील
एक
बोलो.
चीज था जो पार्टनरशिप फर्म्स में आते हैं टैक्सेस ऑफ पार्टनरशिप फर्म्स
हाँ.
रिवेनेशन एंड इंटरेस्ट टू पार्टनर्स डिडक्टेबल 40B I
40B,
think
40B. Yeah, 40B.
40B and second thing once again I just check a same cheese taxation of LLP S is the same treatments of the partnership firm from the remuneration and interest.
Interest. Yes, yes.
It's a different part,
Yeah.
both of them.
See, mostly the taxation part in case of LLP and partnership is almost the same, right?
Okay.
But
Yeah, right.
in case of LLP, the procedure is more rigorous.
Okay.
Like for LLP, you have to
Yeah.
file various documents at the end of the year to the MCA. But in case
Yeah.
of partnership firm, you don't have to submit any document.
Okay.
Basically, taxation for a partnership firm is simplified. It's a simple one. But for an LLP, it's a bit complicated because
Okay.
an LLP is treated as a corporate,
Yeah.
but a partnership firm is not treated as a corporate. For anything that is considered as a corporate, then the paperwork is more because you have to follow all the procedures of the MCA.
Yeah. Definitely.
So a partnership firm is
Procedure of what you said, NCA.
MCA, Ministry of Company
NCA.
Affairs.
Ministry of
MCA,
Company
Ministry
Act.
of Company
NCA.
Affairs. For an
Ministry of
LLP,
is it
LLP has
Ministry of
to,
Company Affairs or Ministry of Corporate Affairs?
sorry, Ministry of I beg your pardon, is Ministry of Corporate Affairs.
Okay, fine.
Okay. Uh, in case of LLP has to register in MCA. But partnership firm, if you want to register a partnership firm, ठीक है, it's basically a simple one.
Okay.
You don't have to go to the MCA. You don't have to file the annual returns. You don't have to file the papers like an LLP or a company.
Okay.
You don't have to the audit the compulsory in case of a partnership firm. But in case of LLP, audit is compulsory.
Yeah. Definitely. Returns, ITR, audit.
Yeah, yeah. Another
Okay,
thing
fine.
is, let me add on another thing. You
Hmm.
will find there are many law firms who state that XYZ advocates and consultants and LLP. But
Okay.
if we follow the Advocates Act, uh, LLP is a law firm. LLP law firm is not basically allowed. So how the big law firms are having they are naming their law firm as LLP? There's a thing. It's LL basically take for example Khaitan and Company. Khaitan and Company has both a partnership firm and an LLP. All the litigations are done by the regular partnership firm. The new tech one, the advisory and the consultancy part is done by the LLPs. So basically, you can call the main partnership firm of Khaitan and Company. There's a mother company, a mother structure. These LLPs are sister concerns. They are because they help them for that for taxation business. The profit is being broken into several parts or separate entities. So the 30% plus 4%, they are it is getting deducted or diverted. So basically, LLP law firms are not allowed. But being advocate, we make the law, so we know the law, basically the loopholes. So we make law firms like LLP, wherein we give only consultancy. We don't involve ourselves in a regular litigation or court litigation.
Okay.
Okay. Good night.
Thank you. Thank you.
Yeah, good night. Thank you. Thank you.
Good night.
Yeah.
Okay. Bye.
Bye.